G'day, Matt. How are you?
Hello, Andrew. I'm doing very well.
Thanks for coming in on a Wednesday. What
I
can I say?
know. Can you believe it?
No.
No.
A bit like last week, we've just been a bit under the gun this week, haven't we?
It's great, but it's also very hectic, and we'll fly by the seat of our pants.
That means we may be skidding on a bit of ice here, so
That's okay.
don't send in questions.
We'll
straight
go
away.
arm in arm, and we'll be safe.
We'll go in.
Yeah.
Look, one of the things I want to talk about today, it's not our major theme, but it's interesting how it has evolved during the week as a major theme, is the difficulty that Australia is facing with the talent shortage.
Yeah.
And the behaviours around the world which are being evoked by that talent shortage, which I want to deal with briefly. But we've seen our Home Affairs Minister come out and look at temporary worker, skilled worker, which paid 43,200 as a minimum, I think it was, or something
it was roughly 53.
And that hadn't been changed since 2013.
Yeah, the Abbott government had paused it.
Yeah, it's just surprising as that may seem. But Labor, honest to their commitments, has elevated that, and it elevated on the basis that what they want to see is the exploitation of foreign workers.
That's right.
And so you'd expect a wage rise to something like 61, 62,000. But instead, we've seen the other arm of Labor reaching in, which is the unionised arm, and making that $70,000.
That's right. A 30% increase.
Well, when you look at the on cost of bringing someone from overseas, so if you add $15,000 to $20,000 on top of that of the on costs, you're now looking at somebody who's too expensive to use.
Yes. Yeah.
And so we've got this great thing where Australia is focusing on migration, which is skilled.
Yeah.
And it's put in a buffer that makes it unaffordable at the same time. And you've got to wonder why these two parts of Labor, one saying, look, what we can't allow is exploitation, but we must encourage foreign labour to come in. And that's going to be the focus. And as we recut migration, it's going to be an easier pathway. And then we say to the host employer, who must be the employer and give the undertakings in respect to that employee, a figure that they're not going to be able to swallow.
Yeah, absolutely. Yeah, it's unusual to see that tension play out so obviously in our space, but it's going to cause real problems. You can't have your cake and eat it too.
No, and it's the problem of a divided party. Can I just say?
Yeah, that's very fair, Andrew. I think that's a good read of the politics.
And there you can hear actually two voices speaking at the same time. And for anyone who doesn't understand that, that's called noise.
Yeah,
that's just called noise. So anyway, look, that's the first part. Well, I wanted to start that. That's not a politics issue, but it shows how conflicting policy can actually damage a labour vision, which is critical for us at the moment. Because we know in relation to skilled labour, were we to fully invest in a skilled labour program internally, it would take 7 to 10 years to meet our labour needs.
Yes.
So actually discouraging migration is a dumb and stupid thing to do.
Yeah, and you add in the impact of the closed borders over the pandemic as well, Andrew.
Now, we've also seen a change in Victoria in relation to child labour legislation. We've seen the muffin break case emerge. Matt, talk a little bit more about that.
Yeah, so the Victorian government has recently tightened up regulations around child employment. And you would think, at first blush, that seems like a bit of an unusual topic, but it's interestingly quite topical at the moment because we've seen in the context of this issue of labour shortage, businesses look for alternative sources of labour. The jam. So we saw it in New South Wales.
The jam.
That's New South Wales, which doesn't have a child employment law, a child labour act as Victoria does. Primary school, 12-year-old children working in a jam factory, putting jam into jam jars.
It's just shameful, isn't it?
It's really fascinating.
And we've seen in America where now a number of states have actually abolished child protection laws.
Exactly, yeah. It's going back to sort of the industrial era.
Yeah, we've got the Dickensian things where people are walking in troughs so they can stand up all day. But I think muffin break is a very serious prosecution.
Yeah, over 300 charges in relation to 3 children under the age of 15 who weren't given proper breaks, were required to work at hours that they shouldn't have, and weren't subject to someone's supervision who had a working with children's check. So it's real sort of, classic examples of exploitation, but there's some serious penalties that could be issued here. And it's one of a continuing trend of both seeing these sort of cases come along because people are increasingly apparently using child labour, but the wage inspector are also putting it under the microscope.
Can I just say to you, I know none of you are going to do this, but I think what Matt and I want to highlight is there are a number of things that are starting to happen as we have talent shortage.
Yes. Yeah.
And there are some which have significant penalties. And so when you're out there chatting to people who think it's a clever idea to have 12-year-olds packing jam, the answer is no. Yeah. Okay, well, let's go on to probably what is one of the more interesting cases. We've seen the new legislation come through dealing with sexual harassment, the stop orders, but also the capacity to seek compensation.
Yes.
And our first prosecutions occurred in less
than 2 months. So when you compare it to the Stop Sexual Harassment Order jurisdiction, which really took well over 12 months for us to get a sniff of anything, and it's barely had any jurisprudence, 2 months, and we're already seeing the first application made, both for the order to stop sexual harassment and seeking other orders, including for compensation. So I think we're really seeing this.
I call it prosecution. Sorry, that's the wrong.
No, that's
okay. But look, the interesting part about this, Matt, is like we were both right and wrong about this. Matt tried to tell me the Fair Work Commission had authority to actually order, and I said to him the lines like, you wouldn't put a fox terrier to guard a prison camp. And Matt was right. They actually are allowed to order compensation, but like in general protections claim, so is the federal court, and nobody in their right mind would stay in the Fair Work Commission.
No, absolutely.
But it is interesting because plaintiff lawyers will jump on this.
Yeah, and it's a trend that we've discussed, and it's interesting, with this first example happened so quickly. 2 months is not a long lead-in for new provisions.
No, let's jump because, geez, we've got a lot on.
I know we do, Andrew.
I know, so let's go to the next case.
Yeah.
So our next case is the firefighter case.
Yeah, we had a good chat about this one.
This is a case of a guy in a Facebook group.
Yep.
Past and present employees.
Yep, exactly.
Don't know the gender diversity of that at all.
No,
so we don't know whether it's men or women or just men. Whatever it was, he shared a nude image. It wasn't of a girlfriend. It wasn't of
not someone he knew, not a colleague, just a random woman apparently.
And his employment was terminated. Courageous thing to do with that union back at any stage.
Yeah, absolutely.
But very interesting, terminated as a result of the policies and procedures that exist.
That's right.
And this has to be one of the classic reminder cases.
Oh, it is. It's all the policies that you've known and loved: social media policy, proper IT use, code of conduct. But the real issue here was that the commissioner was scathing in the fact that.
What was it, man?
Scathing.
No, just
scathing.
I didn't drink water.
Yeah, no, very fair. But said very clearly, the training that has occurred here is insufficient. All you have done is online modules for this training. It was the sort of, to use one of my classic phrases, the set and forget policy.
It is the set and forget. And can we just put a sword to online training?
Yeah.
It is horseshit. I know it's convenient.
Yeah.
But the reality is, neuropsychology of people is they connect and understand by presence. And all of us have been through this with COVID and the difficulty of virtual connection.
Absolutely.
You need to satisfy yourself someone is competent. You need to actually look them in the eye. To know someone is understood it, they need to be looking you in the eye.
Yeah.
And this idea that you can have multiple choices and you can choose and you can fail and you can go back and do it again, it's rubbish.
Yeah.
And it forgets our obligation to people, which is to say, we talk to you about what is good. We don't diminish it by making it something you've got to turn on your screen and tick it.
Yeah, absolutely.
That sort of bullshit just doesn't wash, and it's not real, and everyone knows it's not real. It's just a symbolic gesture to say we're doing it.
Yeah, and importantly, the law is recognising that now as well. So, despite the fact that would be ubiquitous, having online training, we've got commissioners of the Fair Work Commission saying that's not enough. You need to have this face-to-face.
And Matt, I don't know how long we've been saying that, but it's nice to hear some resonance.
Yeah, in 2023.
Yeah. So, look, I think this is a great case to remind people that when you have a policy, you don't just train them as they come through the door in induction. It's based on level of risk.
Yes.
So social media is an ongoing risk.
Absolutely.
It's the sort of thing where you do your yearly training, but then you do slice training to different groups.
Yes.
You'd be aware of risk and you might go to a group of people and do them more. And you'd be very clear about enforcement with it.
Yeah, absolutely.
Wasn't here, and as Matt said, the commissioner was
scathing.
I just thought we'd have that. Okay, let's jump to the next case, Matt. So the next case, well, look, this is an interesting case. I think Nina and I said a few weeks ago, and I just did a presentation to Southeastern Business Network saying, outside of psychological hazards, which is something which all regulators have now put to the top of their priority, for the last 5 to 10 years, mobile plant, motorised plant, and falling from heights has been a real focus. And what we've seen in the cases over a 10-year period is 10 years ago, somebody fell from 4 metres like this poor bugger did and died. You would have seen a primary duty breach with a very significant penalty. In those days, it was somewhere between $200,000 to $300,000.
That's right. Yeah.
About 5 years ago, we started to see that move towards being charged with reckless endangerment because the knowledge of the risk was so high, and the methods of preventing the risk are so obvious and so notoriously known.
Yes, yeah.
And what we've seen today is the first case of a falling from height, which has now been elevated to an industrial manslaughter.
Yeah, which is huge.
It is.
Absolutely.
So
huge.
look, there's no decision made here. This is just a
No,
charge.
it's just to say.
What's happened is, as always, there's been charges under all provisions leading up to it,
Yeah, that's right.
and the industrial manslaughter
Absolutely.
charge. So
Yeah.
can you just accept from us what we're saying in this
Yeah.
category and take it on with psychological hazards, the same thing.
Mm.
You'll have a tariff setting process that goes on where the regulator starts off at a low level,
Yes.
builds it up, builds it up, and builds it up, and psychological hazards, I can guarantee you, in
10 years from now, yeah.
well, I'd say in
Yeah.
3 or 4
Even
years,
sooner,
time,
okay,
they'll leverage it
yeah.
up. But be aware, falling from heights is utterly preventable.
Yes, yeah.
Okay, let's go. By the way, just for those who want to know what the earlier case was that started that ratcheting stage, the last ratcheting case was a case called Montague Cold Stores, where very significant fines were given as a primary duty breach. Since then, we've seen in New South Wales, Queensland, and Victoria reckless endangerment charges for falling from heights. So just putting it up there.
Yeah.
Okay, sorry, Matt, I went on.
No, well, relevant reckless endangerment for our next case as well. This is the employee with the bull bar and the appeal of the South Australian.
Talk about the facts, because I'm not across the facts.
No,
I only
no,
want
that's
5 or
okay,
6
yeah.
just to go with it.
Yeah, so it was a tow truck driver. He attends a truck. The bull bar, while he was winching on the truck, gives away, and it results in an injury actually to the owner of the vehicle because it rolls into that person. So, very clear, serious injury.
So the important part about this was the test of recklessness has been thought by many people to be the probability of serious injury.
Yeah.
That doesn't bear an understanding, because if you read the words of it, it's very clear.
Yes.
But what the full court found in this case is the possibility of serious injury, and then the carelessness or indifference to that injury that gives rise to the elements of the charge.
Yeah.
So probability is greater than 50%. The possibility is
it could.
An educated person would understand that is possible.
It's huge. Huge difference.
So it is a massive difference and shows how easy the courts are moving to get reckless endangerment in as a charge.
Absolutely.
It used to be very hard because there's quite a complex test of what is reckless.
Yeah, absolutely.
I'm speaking quickly because we're going to keep.
No, I know we've got time. No, we don't have time.
We don't have time. Okay, so our next case that we're going to chat about is the AMF case, which is an enterprise bargaining case.
Yeah.
Matt, I think your analysis is this just shows what happens when a whole lot of people think it's clever to fill an enterprise agreement with rubbish.
Yes. I think that's my thesis for the next case. This is the one about the pre-work safety with the rat test, Andrew. But
we'll come back to what I just said. It's very similar.
It is similar. It is in the context of an enterprise agreement. Look,
Matt 1, Andrew 0.
We have had some recent decisions that you would have seen last year about employees being required to take time out of their day to put PPE on in a COVID context.
So can I just say, and the law has always been for that pre-wash, post-wash sort of thing.
Yeah.
It's ordinary rate of time pay.
Absolutely.
It's not overtime.
Absolutely. Here, a little bit different. Employees required to undertake a rat test at home, send confirmation of the negative test before they're allowed to.
So this is the case where they went and argued the most complex way when there was a really simple answer.
Spot on.
So the complex part was they actually determined what is work under the enterprise agreement.
They looked very technically at the meaning of work and said, it's got to be at the workplace and it can't be at home and all this sort of nonsense. But Andrew, very fairly, you picked up on the key point.
Well, the answer is there is an obligation set in statute, Section 25 in Victoria, and replicate every else, that a worker must exercise reasonable care to prevent injury to themselves or others. It's a fitness for work issue.
A known risk in the context of an aged care home for nurses.
Yeah.
Wouldn't have thought it would be a hard argument to run.
In other words, there is no method by looking at someone to determine whether they're injured in the sense of an illness of COVID.
Yes, yeah.
So the obligation falls with the worker to determine as a matter of law and to demonstrate as a matter of law that they're fit for work for something which is a hidden risk.
Absolutely.
Okay.
Absolutely. Yeah.
Hard to sort of understand why that wasn't the argument, but it wasn't.
Yeah. I don't know. Probably just a couple of too clever people sitting in the room at the wrong time.
I think we've talked before that lawyers are inclined to become siloed by the particular talent they execute every day.
Yeah.
And people who are used to dealing with enterprise agreements become obsessed by the words in the enterprise agreement than understanding the integrated nature of workplace law.
That's right.
But the fact is, safety law is king.
It is. Absolutely.
Actually, it's king and queen, just so there's a gender neutrality.
Yes, that's fair.
But it absolutely dominates all other laws, including privacy law and a whole lot of laws.
Yes, exactly right.
So you've got to understand when you're an HR person, you're wearing actually a number of different hats when you're dealing with workplace.
Yeah.
You're dealing with workers' compensation, you're dealing with privacy, you're dealing with discrimination. All that composite of law is people law.
Yeah.
And this case seemed to be forgetting part of people law.
I think it did, yeah, absolutely, Andrew. And it ended up in a wild, technical, detailed decision.
Yeah, which went on for pages.
It did.
Which you can tell I didn't read. Because... Okay, Matt, next case. Let's go on to the case that I wanted to talk about.
Yes, that's right. So, yeah, look, a great classic example, something Andrew and I talk to clients about all the time. When you can avoid it, don't make your enterprise agreements overly complicated for the sake of making them overly complicated. Because here, an employee was found to lawfully be entitled to refuse a direction to perform duties that weren't under their classification. And really, it was
even though the duties were necessary.
Well, that's right. Yeah, they put in an automated gate. It literally took 10 minutes out of his day to watch a video and check to see if someone was at the gate, work out if they had the credentials or not. So he could do it in the course of his ordinary duties.
Yeah.
But it wasn't included in the classification structure, which was built around training modules, reference to appendixes, sort of back forth.
So let's be candid about this, because you and I do a lot of enterprise agreements.
We do.
When I started off doing enterprise agreements, they were 3 pages.
Yeah.
And they'd incorporate the award where it wasn't relevant. But what we're seeing is a whole lot of irrelevant crap being pushed into it, particularly from the union side, who tries to win ground on capacity, win ground on occupational health and safety, and particularly wants to win ground on competence.
Yes.
And so they deliberately insert these clauses, but nobody, because they're not highly skilled lawyers who are doing it, understands the interaction of those things.
Until it goes wrong.
And here we are having a massive piece of litigation where you actually can't direct your worker to do a job which is critical for the safety.
Something so simple, and it comes back to the safety point. Andrew, absolutely.
All right, I think we're on to the main topic. Please say we're on to the main topic of the day.
We are on to the main topic.
We are the main topic. Look at that.
There it is.
Now, Matt, we're going to talk about this at a high level very quickly and come back to the case.
Yeah, absolutely.
Alcohol and drug testing is something which was essentially blue collar.
Yeah.
Going back 25 years ago, when Matt was not born probably.
Gee, I thought that flattered, but no.
There was a New Zealand case which dealt with airlines that talked about what you needed to do for alcohol and drug testing. It became the law throughout Australia and New Zealand. Essentially what it said is, look, there's got to be an identifiable risk to actually undertake it.
Yeah.
For random testing, it must be a high level risk.
Yes, that's right.
And it must be genuinely random.
Yeah.
And you have to have a policy and procedure which you have consulted with people on, that you've then trained and assured they're competent in, and they understand the risk that a breach could lead to termination. And it needs to be educational in nature, not just punitive. And there was a standard that existed at that time, which is the Australian and New Zealand standard that dealt with it. So that was that case. But what's been emergent over the last 5 years, Matt, is it started to sneak into white collar, hasn't it?
That's right, and in a bit of an unexpected way, because as Andrew pointed out, traditionally it was always really this primary focus about safety, about where the intoxication could cause a risk to the health and safety of others.
And that was the primary risk. That was the primary risk.
Primary risk, that's right. But what we've increasingly seen in this white collar space, and really this case, the Robert Hunter case is a great example of it, is this bleeding into the white collar, where it comes to the performance of the role and the standard of the performance of the role and those duties. In this case, it was a financial services employee who turned up to work on a Friday with all the physical exhibiting signs of being intoxicated. He smelt like alcohol, he had bleary red eyes, he was clearly hungover. And his work really was to provide financial advice to people. Now, there was some issue of fact about the fact that there was no tests taken at the time. There was a drug and alcohol policy, but it wasn't quite well aligned with any of the Australian standards. It didn't talk about safety and so on. It was the more punitive form.
Just to give a bit of a highlight to this, I don't want you to rely much on this judgment.
No.
Because as Matt explains it, I want you to understand it's clear the Commissioner in this case made a decision around credit and then fitted the facts and the decision around it. So the facts aren't that good, but please finish. I just want to put that as
So, and the Commissioner said, look, even though you don't have the tests, I'm going to conclude based on the witness evidence that he was intoxicated, even though his evidence was that he'd had 1 or 2 drinks and no one else could give evidence about the number of drinks he had had. So that's the main issue. But on that basis, the Commissioner said, because you've got this policy, and he needs to perform his duties in providing financial advice at a proper and high standard, I'm satisfied that that intoxication inhibits his ability to perform his duties, not in a safe way, but just perform them to the proper standard. And on that basis, found that the dismissal was fair.
And look, I think on that basis, this decision is going to grow.
Absolutely.
And we've seen a few decisions before that have picked at it. Can I just say, without testing, Regulation 107 is a reverse onus provision, and is under the influence of alcohol. In the old case, on under the influence is smashed off the chop.
That's right.
So there is an enormous amount of risk that sits around his decision, which is, it's not a happy decision based on law.
Yeah, I think that's
It's
fair,
a decision where he thought the guy was smashed off his face and formed that view, then thought, how can I stitch together an argument against
That's
it?
right.
That's my feeling. I'm sorry to the Commissioner if he's watching today. But the things that don't change about this is alcohol and drugs are inherently dangerous. So although there is a focus, and I wish the Commissioner had thought about safety law when he said it, the moment I have a drink and I jump in a car, I create a risk. So when I leave work, I'm sent home. You'd never let me get in a car.
No, absolutely not.
So there is an inherent risk to that person and other people's risk when they consume alcohol and drugs. That's just the truth, and that's what safety law exists around. When you go to introduce a policy like this, then the safety law says you must consult with it thoroughly, which requires a risk profiling. And part of the risk profiling here would be your capacity to undertake the work. And that's what this case gives us the way through to.
Absolutely.
Under an award, it's the type of thing that could lead to termination of employment. And so it could be a major change. I think it probably is a major change. And therefore consultation in the process of risk analysis, and then in the delivery of it, 2 different stages is required. And then people must be competent in it. They must understand. You might consult, but that doesn't mean they're competent.
No, exactly.
So then there is another layer of training and competency testing. And if you can't do that, and then the policy must have the methodology that is recognised for appropriate testing
by the Australian standards, aligned with the Australian standards.
So look, I just want, that law hasn't changed.
No.
As Matt's been so articulate about, what's changed is the primary risk that's being looked at. It's saying, yes, safety is an issue, and safety can be the bigger issue. Blue collar. But white collar, if you're unable to do the inherent requirements of your job as a result of being intoxicated, whatever that degree is, and you've got a policy that defines it, you get around Regulation 107. And that's the
big change.
That's the home run, isn't it? If you get your policy right, you go around.
You've got seriousness, calm down. You're laughing.
There you go. We didn't go too overtime, did we?
No.
So let's jump into the case study.
Let's do it. All right. I'll read it, Andrew.
You
sound like you're about to read it. Jonas had been working with Membray Accountants, MA, for 21 years. He was a senior manager. His relationship had soured with his wife, who he suspected was having an affair with his best friend. True or not, he left the matrimonial home on Friday, the 21st of April, 2023, and stayed at a hotel. When he arrived at work in the city office on Monday, the 24th of April, he appeared unwashed, dishevelled, and smelling of alcohol. He sat alone in the open plan office and was observed to cry. His manager approached and asked him to come to a meeting room. When he arrived at the meeting room, there was an alcohol test, on the table, and a document headed alcohol and drug policy.
Not a koala.
That's
you looked at the koala.
So I was like, koala test? Yeah, that's an interesting one. you got to play the government. His manager, Prue, handed him the policy. It was a blur to him. He had never heard of it, never been consulted on it, and pushed it back across the table. She explained it was a lawful direction. She had cause to believe he was under the influence of alcohol. He looked up at Prue, his eyes full of tears, and said, "In the last 72 hours, I have lost my wife, and now you want to take my job away. You can F off." He turned to leave, and she said, "I direct you to go home, and we will meet again tomorrow at 10 a.m. He left the building. When he returned at 10 a.m. the next day, he was tidy and neat, with his wife as a support person. Prue explained at the start of the meeting that Jonas had refused to comply with alcohol testing as required under MA's policy. Jen, Jonas's wife, explained there is no doubt Jonas was drunk. He had wrongly formed the view she was having an affair and went on a 3-day bender. Both Jen and his best friend have rallied around him, made him feel safe in the marriage, and as a teetotaler, it is unlikely he will drink again.
I think we hit up. Oh, there's more.
Oh, there were exceptional circumstances. This was the first time.
That's what Jen
I'll
said.
speed through that. This was the first time he had consumed alcohol in memory. Jonas cried throughout the meeting. Sorry, I should not laugh at that. Prue said she heard all that, but he created a risk to himself, others, and their business by attending work under the influence of alcohol, and she was summarily terminating his employment for breaching the drug and alcohol policy that required, amongst other things, 2 things. 1, not to attend work affected by alcohol, and 2, to submit to an alcohol test when directed upon reasonable cause. It is noted the policy did not have a verification of the handheld test and did not comply with Australian standards.
All right, we definitely got questions.
We do have
and I
questions.
read those.
Yeah.
My question really was the policy enforceable? And the answer is
no. Big old no. No
No.
consultation under health and safety. No consultation under the award if one was
No
relevant.
training and competency.
No, exactly
and
right.
no approved method of testing and
Yes.
regime around it, which is safe and demonstrably fair.
Yeah, so the content of the policy and the manner at which it was introduced both rendered it unenforceable.
Was there a valid reason to summarily terminate Jonas' employment?
I think no. I mean,
Harder question.
a harder question because through his proxy, the wife admits to being intoxicated at work, and there is a safety.
And that meets Regulation 107.
That's
So
right.
That's why I sort of threw it in. So
yeah,
it can look sideways when your policy fails, but the problem they've had is they refer to a breach of the policy.
that's right. That's the key point. It's
So
the
there is
classic,
so there is no valid termination.
No, agreed.
Would Jonas succeed in an unlawful dismissal claim, and what was the likelihood of reinstatement?
I think he would succeed.
I don't.
Absolutely.
For two reasons. One, no valid, but if you got over that line, unquestionably harsh.
Yeah, that's right. That's right. And barely a process to begin with as well.
That's
absolutely. Right. Now, reinstatement, I think probably.
Yeah,
I think
so.
probably.
Yeah, I think Prue's got herself in a bit of trouble.
Absolutely. She's in real trouble. Yeah.
Okay, Jonas brought a workers' compensation claim the day he was sent home, saying he suffered emotional stress from home. That's the relationship. He was dealt with so it should be. He was not dealt with. So he's dealt without
mental.
I wrote this, by the way, and placed at risk into the street, feeling suicidal, drunk, and scared without support or intervention. Can I just say, in workers' compensation law, which I know is Gumby law, okay, so it doesn't relate to any other workplace law.
No.
So would this be a breach of reasonable management action under bullying? Could be, but not necessarily. Is it definitely a breach of reasonable management action?
Yes.
Absolutely.
Yeah, not carried it, slamming the policy down, sending him out the door without checking on his health and well-being. It's all the classic examples.
It's just nonsense anyway. So anyway, not nonsense. It's workers' compensation law. He would succeed.
Yeah, absolutely.
Did Prue breach his safety obligations in not understanding a health check, ensuring he was safe when left, and further ensuring there was someone to care for him when he went home? I think that I don't think Prue would be prosecuted, but I think she'd have a good reason to be disciplined. Yeah. Because what she did is place an employee at risk.
Absolutely.
Terrible risk.
So. Yeah. Without she says that she's formed the reasonable view that he's intoxicated. Well, if you form that view, simply sending him out onto the street out the front without any concern, assistance,
and knowing he doesn't have a wife to go to.
Well, that's right. Yeah, he's literally just told her that my situation is worse. That's right. Yeah.
So look, interesting stuff, I think.
Absolutely.
I think look, the things I want to take out of today, and there's some things I really want to concentrate. One is, I think drug and alcohol policies are good things to have at work.
Yeah.
We're chatting to, when we're doing recruiting today, I made it really clear this office doesn't do lunchtime drinking, except in exceptional circumstance. And if people drink, they go home and they don't come to work afterwards.
Yes. Yeah.
White collars should consider the fact that when people come to work, they come to actually perform at the highest level of the inherent requirements of their job. And if they're going to be affected by drug and alcohol, yes, there should be an educative element to it. You shouldn't be shooting people on site with it. Yeah. But at the same time, it's not, if you're unable to do your job, if you're unwilling to be fit, willing and able to do your job, what trust and confidence could you have in an employee who thinks it's okay to come to work affected by alcohol and drugs?
Absolutely. Well, drug and alcohol, it's cultural. So if it's cultural and you're not applying some sort of standard about that behaviour, you come into these things.
So that's one thing I wanted to say about today. This is something which is a learning. We've now got a judgment after a series of what we call discussions and other judgments that say, look, this is a course you can take it up and take a chance. The second one is where you see really high levels of risk exhibiting in your workplace, like heights, psychological hazards, and motorised and mobile plant. Understand that the regulator is taking a very different view, and understand the courts are taking a much more stringent view and a much more aggressive in the penalties they're handing out. And finally, we're seeing the new bits of legislation starting to pervade into everyday practice. We've seen safety regulators prosecuting for bullying, for sexual harassment, and now we've seen the first cases starting to come out of the new legislation around sexual harassment. I want you to understand this is a whole new world. I don't want you to think that 6 months ago and now is the same. No,
absolutely.
This is not a matter of tweaking the policy. Somebody said at a presentation, so what do I need to do the policy? I said, well, step back, what do you need to do at a governance level, given these positive duties that now exist to provide a safe place of work? That's the question you should be asking. That has a whole lot of steps along the way.
Absolutely, Andrew.
And I guess for Matt, Nina, and I, we've spent the last 12 to 20 weeks saying it's coming.
Yeah.
And what we're now starting to see as the wave crashes is every week a new prosecution from the regulator, every week a new exploitation of new provisions under the legislation.
Yeah, exactly.
Please don't think you can just change your policies and get out of jail.
Yeah, very true. And also maybe don't hire children.
Yeah, look, on that note, Matt, see you later, mate. Thanks very much. Thumbs up. Don't forget, thumbs up. Cheers. Bye-bye.